your head up and down. Can anyone, you can't hear me. Okay, there we go. Okay, Natalie, we are ready for 2292.
Okay, thank you. Sorry, I couldn't hear you there. House Bill 2292 creates exemptions in the Open Records Act for cybersecurity assessments, plans, and vulnerabilities. Section 1 amends KSA 45217 to define those new terms. So we're defining security assessment, cybersecurity plan, and cybersecurity vulnerability. And then Section 2 amends KSA 45221 to provide that a public agency shall not be required to disclose records of emergency or security information or procedures of a public agency if that disclosure would jeopardize the public safety, including records of cybersecurity plans, cybersecurity assessments, and cybersecurity vulnerabilities or procedures related to those items. And I can take any questions.
Do we have any questions for Natalie? Do not see any. Thank you, Natalie. We will start with our proponents, and the first one is Ellen Parker, and I believe she is on WebEx.
Hi, Chairman, can you hear me?
I can, yes.
Hi, Chairman Patton and members of the committee. Thank you for the opportunity to speak to you remotely today about why Water One supports House Bill 2292. My name is Ellen Parker, and I'm an associate attorney at Water One. Water One is the public water supply system for 455,000 customers in Johnson County. Our service territory spans 272 square miles, and as a public entity, we are subject to the Kansas Open Records Act. Water One uses a sophisticated SCADA system to conduct the water production and treatment processes, which is operated by trained professionals 24 hours a day, 7 days a week. It's basically a mix of hardware and software that runs our system. Water One recognizes and appreciates the responsibility to do everything it can to keep the drinking water safe for our customers. Thus, we place a high priority on security, including cybersecurity. As cybersecurity threats continue to evolve, Water One knows that it's important to perform risk and resiliency assessments, which include looking at both our physical security and our cybersecurity. It's important that the results of these assessments, which include any vulnerabilities that are exposed, are not accessible to anyone who doesn't have a reason to know. We believe that the added definitions and expanded exemptions to include cybersecurity assessments, vulnerabilities, and plans as security information will help utilities in their efforts to protect sensitive information about their facilities and make them less vulnerable to cyber attacks. On behalf of Water One, I respectfully request that the committee pass HB 2292. Thank you, and I'm happy to take any questions at the appropriate time.
Thank you. Committee, any questions? Not seeing any. Thanks again. We'll move on to Amanda Stanley.
I figured out the microphone this time. Thank you so much for allowing me to come back and testify again in front of you today. My name is Amanda Stanley. I'm General Counsel at the League of Kansas Municipalities. I think Ellen did an excellent job of explaining why this bill is so important. Unfortunately, as we've all seen in the news, cyber attacks continue to increase. While we do believe there are current exceptions to the Open Records Act where these records could be disclosed or could be withheld because of important privacy and security interests, having an explicit exemption in statute can help result in decreased vulnerabilities in our system. When you show the vulnerabilities out there, it actually results in increased attacks afterwards. And once any entity, city, business, company has been attacked, they're more likely to be subsequently attacked as those vulnerabilities are exposed and the press reports on them in increasing numbers. So this bill is important, and it does emphasize what our state's policy position is on cybersecurity and making sure that we do not subsequently allow additional attacks by making public potential vulnerabilities in our systems. I'm happy to stand for questions at the appropriate time.
Any questions? Not seeing any. Committee, you also have written proponent testimony from the Kansas Press Association. Anyone else here or online that wants to testify as a proponent? Not seeing any. I don't have any neutral or opponent testimony listed. Is there anyone here? Yeah. Oh, you have questions. Representative Humphreys? Sorry.
Thank
You can only focus in
Thank you,
one
Mr.
spot.
Chairman. Thank you, Representative, so I guess Amanda, maybe you can answer this question. But so my concern is, lots of exemptions to, the Open Records Act. I mean, how did we handle sensitive things before? And so, I mean, I would just like, since there's no opponents or neutrals, I guess I'd kind of like to hear the other side of the story. If
Sure, I can try to answer
yeah.
that.
I
tend to
understand.
stick on
I
one
understand
side.
where you're at, but like, how are things handled now? Because lots of exceptions kind of make me a little bit uncomfortable.
I think currently most of these records could be withheld under A12 and A10, which is your criminal investigation, and then your generalized security records. There already is an exemption in statute for records that would expose security threats. We use it for power plants for those examples, or a good example, for example, is you wouldn't want to disclose exactly where your police officers are patrolling at any given time for a security reason. You wouldn't want to say, this is exactly where the judge will be at X time of day. So those kind of records. But as technology has continued to expand, we didn't bring this bill. I'm not sure who originally brought it last year. I feel like it was a state agency that actually brought it last year. But their concern was, let's just make it very explicit what these definitions are so that we aren't constantly trying to argue about, does cyber fit under our generalized records? Like I said, I tend to think it already falls under A12 and A10, but this creates certain carve-outs.
Okay, thanks. I appreciate that. Thank you, Mr. Chairman.
Mr. Chairman,
Yes.
the Secretary of State is also a proponent and was planning on testifying.
Then go right ahead, sir.
All right. Thank you, Mr. Chairman. We're the agency that submitted this bill last year where it passed through the Senate 39-0, but ended up being cut off because of COVID. And the reason we initiated it is our office was getting a lot of requests for very detailed information on the cybersecurity of the election systems. And as was just pointed out, there isn't a spot-on provision in Kansas law that would be an exception to KORA. The Kansas Cybersecurity Act exempts agencies that have elected officers. There's some federal statutes, but they again don't always hit right on. And KORA itself, exemption 12, was intended to be for physical security, but it references physical security. I don't think the cyber issue was around when it was passed. And we've never had a problem with Kansas journalists on this issue. They're very understanding that they don't want sensitive information. It's in our office's interest to educate the public on the threat. But occasionally we would get national special interest groups would demand very detailed information and point out that there doesn't seem to be an exemption in Kansas law to this. In this last election, one group sent KORA requests to all 105 counties demanding all their software. We got them to back off on that. This morning, a county was hit up with a request for all the software for the poll books. And if that was released, it would be a roadmap on how to sabotage the systems. And so we thought it would be best if KORA was updated to specifically reference cybersecurity as a basis to not release information. And that is our testimony. I'll stand for questions at the appropriate time.
Very good. Any questions? I'm not seeing anyone with questions. Good. Sure I didn't miss anybody. Okay. Okay. Again, no opponents or neutrals that I'm seeing. No one's waving at me online or in person. So we will close this hearing on 2292 and then open the hearing on 2011 and have Natalie tell us about this one.
Thank you, Mr. Chairman. House Bill 2011 removes the authority of the Secretary of State to prosecute election crimes. The bill amends KSA 25-2435 to remove the Secretary of State from the list of authorized persons to prosecute election crimes. That would leave the Attorney General and the appropriate county or district attorney in the jurisdiction. The bill also amends subsection G to provide that if the Secretary of State becomes aware of evidence of an election crime, then the Secretary shall promptly inform the Attorney General and the appropriate county or district attorney and provide assistance in the investigation or the prosecution. And I can take any questions.
Questions for Natalie? Representative Carmichael.
Thank you, Mr. Chairman. My recollection, Ms. Scott, is that we've seen this legislation previously. I think it was perhaps in Chairman Jennings' committee, where he ruthlessly gutted a similar bill to form the Criminal Justice Commission. But there was also a bill that was proposed by the AG's office and then amended by Chairman Jennings' committee, and it was making good progress, but somewhere it went astray, if I recall. Do you know what happened to that good idea that we had a year or two ago?
Mr. Chairman, that version of the bill from last year was House Bill 2042. It looks like it was referred to you guys. You had a hearing and you passed that legislation out of your committee, but then it looks like it was sent to appropriations, probably to be blessed, sent back to you. You passed it out again, and then it died on general orders.
That's helpful. I think I thought we'd actually made progress with the bill in commerce, or excuse me, in corrections as well, but it's immaterial.
It was in corrections. So that bill was in corrections, House Bill 2042. Yep.
Okay. And so it's been ruthlessly appropriated by Chairman Patton for the glory of his committee this year. I withdraw my question. Thank you, ma'am.
Any other questions for Natalie? Okay, we will move on to proponents, and first one up is Clay Barker.
Thank you, Mr. Chairman. Clay Barker from the Secretary of State's office again. We're in favor of this bill, and the Secretary does not want the prosecutorial authority to go after potential vote fraud. He's declined to use that authority. We have a memorandum of understanding or agreement with the Attorney General's office, whereby we will screen any potential criminal or action regarding elections, and we will pass it on to the Attorney General. If we think there's something valid there, we'll also give technical advice to the Attorney General. Some things that may look like a crime really aren't, and other things can be and need to be properly investigated. And we can also refer it to the county district attorney or county attorney. The two reasons we don't want this power, and some people ask, why not just sit on it and not use it, is first of all, criminal prosecutions are a specialized area of law, and our office is not equipped, resourced, or staffed to handle it. We have two attorneys here, and we do business law, election law, a vast number of areas, but none of it is criminal, and none of us have criminal expertise. And as best I can tell, the only time the Secretary of State's office has had a lawyer with any criminal prosecutorial expertise was when now Eric Rucker, former senator and former deputy or assistant Secretary of State, was here for about 8 years. He had some experience. Before that, for 160 years, the office has not had that type of experience. So we just don't have it. And if a future Secretary of State were to try to bring criminal prosecutions without having adequate resources and expertise, it could go off the rails in the wrong direction. That criminal prosecution should be left with the experts that can handle it. The second reason is just by having the authority to bring criminal prosecutions, even if we never intend to use it, means we can be sued at times because a plaintiff could claim that they are refraining from acting under a fear that the Secretary would suddenly decide to use his or her power and prosecute them. And we just want to avoid being a target for litigation if we can help it, based on a power we'll never use. And that ends my testimony, Mr. Chair. I'll stand for questions at the appropriate time.
Thank you. Committee questions? Representative Wheeler?
Thank you, Mr. Chairman. Thank you, sir. I appreciate the position of the Secretary of State a great deal. I do have a question, however, about an agreement between the Secretary of State and the Attorney General. Attorney General is a dear friend of mine, and I respect him immensely, but a referral to the Attorney General, will he then in turn refer to the local prosecutor? Because the Attorney General cannot go in to a local jurisdiction without the request of the county or district attorney, except under specified circumstances, and election fraud is not one of them.
The extent of our memorandum of agreement with the Attorney General is if we see suspicious activity that based on our expertise, we think there's grounds for possible election crime, we will inform either the county or district attorney or the Attorney General, and the Attorney General with their own process may simply turn it over to the local authorities. I don't recall a time when the Attorney General himself, his office, prosecuted election crime. It may have happened. Counties usually handle that.
Thank you, sir. I appreciate your response, sir.
Further questions? Representative Carmichael, live and in person.
Can't even remember how to push the button. Thank you. My state-owned computer displayed the blue screen of death twice in a row within the last 15 minutes. So nice to see you all. My recollection of the current law might be a little bit different than my friend from Garden City. I thought that we do have some specific authorizations for the AG to prosecute election crime. It may, in fact, be part of the same statutory scheme, but could I just ask that our research folks take a quick look before the final vote is taken and make sure we get the right answer to that? And my friend will prove me wrong once again, I'm sure.
Representative Wheeler.
Oh, Representative Carmichael, I never set out to prove you wrong. You do quite well on your own. Some of the laws were a little different during the Secretary of State Kobach's period of time where he succeeded in getting the prosecutorial power. Could generally, unless legislative research can indicate something new that I am unaware, if a prosecutor, or I even think a sheriff, commits a crime, the AG can come in without request. There are some exceptions like that, but I am not aware of the election law. And if I am proved wrong, sir, whatever within limits.
You and I will, we will engage in the customary penalty. Yes, thank you.
Any further questions?
Mr. Chairman, I would just, this statute that's amended in this section, you'll see that this statute expressly gives the Attorney General the power to prosecute these types of crimes. And so by removing, I just want to clarify, by removing the Secretary of State, we're leaving either the appropriate county or district attorney or the Attorney General.
Representative Carmichael.
Mr. Chairman, Ms. Scott's recollection is consistent with my own. Notwithstanding that, I will still claim that I was wrong so as to pay the appropriate penalty to the distinguished representative from Garden City.
Representative Wheeler.
Thank you, Mr. Chair. And you will notice, Representative Carmichael, that she said this bill gives the power. I was talking about 6 preceding powers. But let's leave that be.
Now I withdraw the, you equivocate. Now I'm not willing to buy.
Okay. Now I will say with regret, because I've wanted to see this corrected, I likely will not vote for this bill. I think that power rightfully belongs in the local prosecutor's decision and not that of the Attorney General, unless the local prosecutor has a conflict or another reason to bring in the Attorney General.
Representative Heiberger.
I just want to point out that the Attorney General's independent authority is in existing law, and it's been there before we amended it out. This. So I guess I don't understand the representative's concerns.
Further questions? Okay. Committee, you have written proponent testimony from the Attorney General. Is there anyone else as a proponent? Not seeing any. We will move on to opponent or neutral, which I'm not seeing any. Do we have any? What about opponents? None of those either. So we'll close this hearing. Thanks for looking out the hall, Representative Jennings. Close the hearing on that one. Open the hearing on House Bill 2390. And we'll head back to Natalie.
Thank you, Mr. Chairman. House Bill 2390 is your annual legislative review of exceptions to disclosure of public records under the Kansas Open Records Act. So I'll kind of explain this process for the members who might be new to this committee. Under the Kansas Open Records Act, any new or substantially amended exception to disclosure expires July 1, 5 years after it gets put into place. So you probably have seen that in some bills as you read that create a new open records exception. And so that expiration happens unless the legislature acts to continue that exception into existence. And so before the exception expires, the reviser of statutes certifies to the president of the Senate and the Speaker of the House of Representatives the statutory language and citation of each exemption that will expire in the next coming year. So under KSA 45-229H, the legislature is directed to review each exception before its expiration and consider what specific records are affected by the exception, who does the exception uniquely affect as opposed to the general public, what is the identifiable public purpose or goal of the exception, and whether the information contained in the records may be obtained readily by alternative means and how that may be obtained. So Kathy also distributed 2 other documents from our office. One of them is just a list of the substantially amended exceptions, the new exceptions, and then the previously extended exceptions. And then the other document is an actual attachment of the language that you'll see in the statute for each one of those exceptions. And I can take any questions.
Thank you. Representative Carmichael.
Thank you, Mr. Chairman. Ms. Scott, could you explain to us what's meant by the previously extended exceptions, the bottom third or so of that list?
Yes. So if you also open, let me open this packet here so I can. So once you guys have reviewed those exceptions once, they come back to you for review one time. So those are the list of exceptions that have previously been reviewed before, and now this will be your last review of them.
Meaning that unless something different is done, if they are approved again this time around, they become permanent?
Yes, permanent insofar as we won't continue to bring you them for review. They can always be changed by legislation afterwards, but yes, yeah.
Thank you.
Any other questions for Natalie? Seeing none, we'll move on to proponents, which it's really exciting that we have proponents on this bill because usually we don't have any. Amanda Stanley's up first.
Thank you, Mr. Chairman, for allowing me to come back again today to testify in front of you. I'm Amanda Stanley, General Counsel for League of Municipalities. You know, I was told my first year working at the League that this is the bill you should always watch because if nobody shows up and says they're important, people start to ask, should you need them? So that is why I'm here and tends to be why I'm here every year on these. I'm not going to talk about all of them. I'm just going to reference my testimony. There are 4 exemptions expiring that we think are important to include. I will say one's not actually an exception. It's more a definition, which is kind of strange, but it's 45-254A, which defines body cam footage as a criminal investigation record. We think that continues to make sense to define it as a criminal investigation record, and then it goes through the district court for the various balancing tests if it's disclosed. But the other one deals with probable cause warrants, and we think those all continue to make sense, and I'm happy to stand for questions.
Any questions? Representative Carmichael.
Thank you. Surprise, surprise, there's actually a question about this. Last week or the week before, there was a prominent case decided in Wichita by the district court relating to body cams and the investigative exception, investigative material exception. Also dealt with videos and whether they're discoverable or, subject to CORA. If we let this provision expire, or did not renew it, what would be the consequence?
I think that would cause a lot of unintended consequences, maybe intended, but body cam footage has a lot of personal privacy information. When you talk about witnesses, you talk about victims. If you don't classify it under something, it becomes very ambiguous if it could ever be withheld or redacted. So if you were going to make changes, I really think it needs careful study. You wouldn't want victim statement body cams just out there because there was no reason to disclose them. I think it makes it messy. I don't think it would change anything in that Wichita case necessarily. I haven't read the district court opinion, so I don't want to opine on that.
The opinion's
But
not published yet.
so,
We're waiting for it.
well, then I don't feel quite so behind. But it still has a balancing test, and if you feel that an entity has not disclosed it appropriately, it can still be challenged. Extending this exemption does not change that. But if you let it lapse, I'm not sure where they would fall in at all, and I think that would add a lot of confusion to the current system.
I appreciate the explanation, and I'll decide whether or not we ought to amend this or not. Thanks.
Any other questions for Amanda? Not seeing any. Thank you. Next, we have Joseph House.
Thank you, Mr. Chair. My name is Joe House. I'm the Executive Director of the Emergency Medical Services Board here in Kansas, and we appreciate the opportunity to provide testimony also in support of a bill that doesn't necessarily receive a lot of proponents, or any hearings. So we have two sections of this bill. Both relate to health personnel records. One is lines 38 through 43 on page 22. That certification allows our board to issue investigative subpoenas to potentially gather patient care records, care that's provided during our discipline side of things. And as we move through looking into those disciplinary matters, in those circumstances, we're looking at the conduct of our licensees, not necessarily as they relate to the care that they provided, but looking to see to determine whether harm or what degree of harm occurred, if any. So those are legally compelled records. The patient could end up giving that involuntarily just because it's part of our process, and we feel as though that should probably remain protected and not public or not available for public consumption or disclosure. The second portion in here is line 36 of page 23 through the end of the bill. This language also protects patient information and deals solely with the Advisory Committee on Trauma. I think a bill that you heard or that you worked on the floor earlier today has the same language in it exactly. And so that's also the same scenario without that protection. These peer review committees that meet in the closed session of what otherwise would have been an open meeting, that prevents them from being able to disclose anything that they talk about outside. This exemption gives them the ability to disclose to a single individual, that's the Secretary of Health and Environment, and the one that can make recommendations based upon their findings, whether that's positive or negative. And so again, both situations cover things where patients may not have necessarily voluntarily wanted their records to be out there, and so this protection prevents those from being involuntarily released. And I'm happy to stand for any questions at the appropriate time.
Thank you. Questions, Representative Carmichael?
Thank you, Mr. Chairman. In addition to whatever protections may be available under the Kansas Open Records Act, I presume that your clients or your patients are entitled to the same privacy protections under the Health Information Portability and Privacy Act, HIPAA. That also applies to your activities, I believe, as well.
You are correct, yes.
And so there's nothing that you're trying to do here that would actually diminish or curtail rights under HIPAA, because we couldn't do it even if we wanted to. I'm sure you understand. Now, is the fact that an EMS unit responded to a particular location at a particular time, was on scene for a particular number of minutes, is that protected by CORA, or is that interpreted somewhat like blotter information, was the old phrase that we used involving police calls?
Right. I believe that depends upon how it is released. Our services, or the services that we oversee, typically they won't give a specific address. They may say the 100 block that it occurs in, an approximate time and such, to prevent that. But anything that can identify that person to that medical condition would be under the federal law and not to be disclosed.
But you do disclose the general concept that a unit arrived somewhere at or about and on or about particular locations. So if we want to know, for example, whether EMS is being appropriately utilized, is everybody spending all their time in the barn, or are you actually out responding to calls? You're not trying to limit access to that general type of information, are you?
That would be correct. We're not trying to limit that.
Thank you. I hope my friends at Sedgwick County Counselor's Office were listening. Thank you.
Any further questions? Do not see any. Thank you. I do not have anyone else listed as a proponent. Is there anyone else here or online as a proponent? Not seeing any. Anyone as a neutral? What about an opponent? Seeing none, we will close this hearing as well. Let's go back to where we were on Thursday, working House Bill 2093. We will have Natalie again refresh our memories on this one. And committee, we're going to try to work a bill. We're going to see how this goes. If between Natalie and I, we can get it sent out to you, any amendments. If not, we will pause this and pick back up tomorrow, but we think we've got it figured out. So be patient.
Mr. Chairman, House Bill 2093 increases the criminal penalties for fleeing or attempting to elude a police officer when operating a stolen vehicle. And it also makes fleeing or attempting to elude a police officer evidence of intent to commit theft of a vehicle. And I can take any questions.
Any questions for Natalie? If not, are there amendments? Representative Owens.
Thank you, Mr. Chairman. We'll give this a go again because we only got to one of the 3 amendments that I had prepared on this bill. So this one, hopefully we have addressed the valuation of the vehicle. So if we can disseminate this amendment, I believe you guys already have copies of the other 2.
Mr. Chairman and Representative Owens, would you like just this one distributed right now, or would you like all 3 redistributed?
Go ahead and redistribute all 3.
Okay.
While those are being distributed, we'll jump back on the conversation from last time. We were kind of trying to figure out the best way to make sure that you know, it is a felony charge when somebody's vehicle is stolen. And so we didn't feel like currently registered made sense. So we kind of went back and forth and ultimately settled on the value of the vehicle being at least $500, but less than $1,500. So if your junker in the back of your yard with the wheels falling off and all that other stuff, you take it to the scrap yard, that's going to be $100, $150 tops. This puts that minimum at $500, less than 15, but more than 500. So with that, I will stand for questions and wait for everybody to receive that amendment.
Representative Carmichael.
Thank you, Mr. Chairman. A question for the carrier and to appropriate the idea of one of our colleagues who's sitting around here. What if it's a golf cart? It's worth $503. It's got 4 wheels. It's motorized. In some circumstances, people even put tags on the back of them. Are we going to be using this to charge kids who go take a joyride with the golf cart in the middle of the night, like on Caddyshack?
Fair question, but I've also got to have a little bit more faith in our law enforcement in their discretion of what criminal intent is to state that, you know, the average golf cart that works well is actually worth more like $2,000 or $2,500 and not $503. So, and they are oftentimes registered and could theoretically be, at least in Heston, a primary mode of transportation.
So the simple answer is yes. We're going to charge that kid who's doing the Caddyshack thing with a felony.
I would say that it would be up to that law enforcement agency and then ultimately up to the district attorney.
And I would say it's up to us, but thank you.
Well, committee, I have bad news for some of you and good news for others. The bad news is the emails are bouncing back to me. So instead of spending your afternoon figuring this out, we will have Natalie refresh our memory again tomorrow on 2093. All 3 bills I have up to work today have some sort of amendment. Yeah, so you guys can continue to discuss this offline, and we will be back tomorrow. So thank you all. No reason to sit around and watch me stare at my computer. We're adjourned. We'll see you tomorrow. Thank you.